Hello everyone, welcome back to another episode of Providence Money Wisdom Podcast. I'm your host, Isaac, Client Advisor at Provident. Joining me today is Christopher Tan, Founder and CEO of Provident. Hi Chris, great to have you back.
Hi Isaac, it's good to be back.
So another month, another episode.
Yes.
And for this month's BT article, you wrote an article titled Beyond the Trust Deed, a team-based approach to legacy and estate planning. So as with all BT article podcast episodes, I have to ask you what prompted you to write this article and why do you feel it was important to address the misconceptions about trust and estate planning?
I think firstly, which is something I've said before, that a lot of people may think that, when it comes to estate planning, when it comes to legacy planning, it is always about distribution. And since it's about distribution, then besides wills, trust is then used for distribution. And that's about it, right? So we oftentimes get inquiries, they come to us and they'll tell us, I want to set up a trust, but Isaac, in the work that we do, you do realize that when we talk about legacy planning, especially legacy planning, is beyond distribution. And when you talk about distribution, it is beyond just using an instrument like trust. And trust has its limitation. It cannot do everything. And so I thought it'd be good to write an article to talk about some of the things that people may want to consider if they do really want to use trust for estate and legacy planning.
Right. In the article, you also mentioned that there are more families that are setting up trusts due to increased complexity in wealth and family structures. So, as client advisor at Provident, I also noticed that there's a lot more trust queries. I was thinking perhaps it's due to the demographic of Singaporeans, right? It's an aging society, but of course in the article you stated that it's because of family structures and complexity in wealth. So could you expand on this for our listeners?
Yeah, I mean, to begin with, yes, it is true. It's because of the demographics. I mean, a lot of Singaporeans are getting older, and also a lot of Singaporeans or a lot of clients domiciled in Singapore, they are also getting wealthier, right? So they have amassed huge amount of wealth, and a lot of times these monies and these assets that they have, it is not in Singapore alone. They have monies, various jurisdictions. They have also got some of them blended families. I use the word blended families to mean that there are families whereby they have children from previous marriages, right? Unfortunately, they may have divorced from their previous marriage, and now they come together and they co-parent children that were from previous marriages, right? So that sometimes can make distribution, estate planning, and legacy planning a lot more complex. So I think because of all these reasons, there have been increasing number of inquiries for clients who want to make sure that all these things that they own, all the assets that they have amassed, they are properly being distributed.
Right. Actually, that's a great point that you raised up because I didn't account for the rising divorce rate as well, which could lead to more family complexity.
Yeah, and one more thing, of course, I also did mention in the article is that I think a lot more people are becoming more aware on the use of legal instrument, legal structures such as a trust. They know the benefits of a trust for asset protection. And with that awareness, of course, a lot more inquiries. People are thinking whether they should do it or not. Also, I think because of the wealth that they have amassed, they are realizing that they cannot just sort of like appoint their own family members to be trustees. Because the problem with human trustee is there is that longevity risk, right? I mean, the trustee, one day they will also pass away. How do they make sure that the assets that they have amassed perpetuates across generations? Some of them, they want to make sure that the trust perpetuate for more than 100 years, which obviously you can't do it in Singapore. You got to do it in a different jurisdiction. But how do they do that if they appoint human trustee? So, well, the solution seems simple. Just appoint a corporate trustee. But, well, you have been in some of these meetings before. It's not as simple as appointing a corporate trustee.
It's not.
Right? I mean, finding one suitable corporate trustee is already difficult. But there are also many limitations of a corporate trustees. And I thought addressing it in an article would be useful for people to know.
Right. And in the article, you stated that many clients assume that, once you engage a corporate trustee, they can do everything, right? But what are the most common misconceptions about the role of a corporate trustee that you want to clarify?
I think many times clients think that, once I hand over my asset to the corporate trustee, and before I even talk about that, I think some clients do not understand the emotions that happens inside of them when they actually hand over the asset, when they actually hand the asset over to a corporate trustee, or to be more accurate, when they hand over their assets into a trust, right? They are no longer the legal owner of that particular asset, right? And it can be quite scary, right? Because you have this 10, 20, 30, $50 million worth of asset. It used to be in your name, and now you are giving it away into a legal structure like a trust, and you no longer legally own it. A lot of times, I think people underestimate their emotion. It can be quite scary, right? And then after that, they appoint a corporate trustee. They don't even know who this person is until maybe a few months ago. And they are really dealing with the employees of the trust. I think there is also that emotional challenge that they will face on, wow, can I really trust this person to manage my trust? And what if this person that I like quits and join another trustee, So these are the things to consider. But to your question, I think sometimes we think that a corporate trustee can do everything. And in the article, I was just simply unpacking it and say that the trustee basically takes instructions from you on how you want to deal with the assets. They are not investment specialists. They are not lawyers. They are not wealth advisors. And it's very important to understand that, because in the administration of the trust, it is not as simple as, for example, I tell the trustee, please distribute money to my children when they are 30 years old, 40 years old, 50 years old. Please distribute money when a life event happens. It sounds simple, but because the trustees are not investment professional, they will stick to what you tell them, either in the letter of wishes or in the trust deed, and they will, sell the investments when the child reaches 30 years old or 40 years old. But maybe that year is a very bad year to sell investments. Maybe this thinking about when do I sell and how should I rebalance the portfolio before I even distribute needs to be considered. But you cannot expect the corporate trustee to do that, because they don't do cash flow. They don't do investment management. So I was just trying to help people understand that you cannot just depend on the trustee and that they will be able to do everything for you.
Yeah, especially when it comes to drawdowns, right? You have to ensure that there's enough liquidity. Just like when we think of GIC, how they are handling our CPF monies, right?
Yeah.
It's not so straightforward that we just invest the assets, then as and when we need the money, we just draw it down. I think we have this so much more complexity to it that as a trustee, they might not have the expertise or maybe even the willingness to do it, right? So most probably they'll just follow what's stated on the trust deed, on the letter of wishes, and then they just try their best to just do what they're legally obligated to do.
And I mean, it's even if they're willing to do it, and I mean, again, you have been to many of these meetings, the trustee will tell, no, we can't do it. They're not licensed to do it. They are not competent. They're not trained for that. But I think we underestimate the importance of that, because remember, you are handling over tens of millions of dollars to this corporate trustee who is supposed to act in your interest. They are a fiduciary. They are supposed to make the best decision for you, but they are not trained in investment, right? How do we even expect them to be able to ascertain whether the investment has been managed properly? It's difficult, right? Yeah, so I think that's something that settlers or people who want to set up a trust, they need to know.
Can I just add a counterpoint to that? For corporate trustees, they typically encourage that you have an investment professional, right, to be in charge of this. So wouldn't that mitigate some of these risks that we were talking about?
It will help, but I mean, if you don't have the competence, how do you then really ascertain whether the investment manager that you appoint is doing a good job? It cannot be purely based on returns, right? Because we know that, and We talked about that actually in our previous episodes on ILP. Shucks, I brought that term again.
No, close that.
Close
Can
the
of worms.
episode. Yeah. But it's the same, right? I mean, if someone show the corporate trustee that, our performance over the last 12 months have been great. It's been giving 5 to 6%. Is that really good? Right? Because if you look at the last 12 months, the markets have returned more than 5, 6%. But if the corporate trustee delivers 10, 15%, is it really good? Because are you then working within the mandate? Is the standard deviation acceptable? And your approach of getting that 5% or that 10% or that 12% does not guarantee that in the next 10 years you're going to get the same return. Is your investment manager really adopting an approach that gives the beneficiaries the highest probability of success? And do you know what is the return that the assets need to give so that the trust asset can be financially sustainable over that 99 years or that 50 years that you need the money to last? You can't expect the trustee to know how to do that, right? And so yes, appointing an investment manager helps to mitigate some risk because at least you're outsourcing the day-to-day management of the investment portfolio to someone. But how do you really judge whether this investment manager is doing a good job? And look, it's not theoretical. We have gone into meetings before. We have asked the trustees this question before, right? And trustees reply, even big financial institution-based trustees, bank trustees. The answer is, sorry, we are not investment professional. We can't do it, right? So I think clients need to understand, when you place your assets on trust, in a trust, and you appoint a corporate trustee, you are not going to be able to get that kind of advice because it's not their job. To put it plainly, it's just not their job. Their job is not to do investment management.
Okay, so Chris, actually the main point of your article then is, of course, a successful trust having a multidisciplinary team, right? So let's dive a bit deeper into that, or rather, how do you define a multidisciplinary team? Like who should be involved then?
Yeah, so in the article, I listed down a few professionals that must be involved. And of course, the list is not exhaustive, right? But for most of the cases that we have seen, I think these few professionals are really hygiene, basic, right? Of course, people will have got GCBs to manage and all that. You may have to hire a property or real estate specialist to do it. Yeah, but in that list I gave, of course, you will need the wealth advisor. And we do that job, right? And the purpose of the wealth advisor is really to do all the cash flow projection. In the trust, you say, distribute money on the 5th, 10th, 20th year. Who is going to do the cash flow for you? The cash flow plan for you. The trustee is not going to do that. The investment manager is not going to do that. It's the wealth advisor that will do that. Who is going to estimate the returns that are needed to keep the assets financially sustainable? The wealth advisor is going to do that. Is there a need for insurance policies to be bought? Who is going to do that? The wealth advisor will do that. So the wealth advisor is the first person. This person knows the overall financial picture. This person knows the ikigai goals of the settlor. And so therefore, he is actually the architect and he is the coordinator of the entire legacy plan. So the first person, wealth advisor. Of course, then you need the investment manager to be doing the investment management, to be creating the asset allocation to meet the estimated returns that the wealth advisor has estimated, right? That has calculated. The investment manager is the one responsible to pick the instrument. He's the one that's supposed to monitor the performance to make sure that the investment performance and the risk is in accordance to the mandate. So the investment manager is very important. Of course, you will need a lawyer because trustees are not lawyers, right? The lawyers are needed to draft a brand new trust deed, or if they are taking the standard trust deed template from the corporate trustee, they will look at the trust deed and they are the ones that will strike off clauses that are not beneficial for the settlor. They will strike off clauses that maybe give the corporate trustee too much power than they need. They make sure that your trust deed and your letter of wishes is written in a way that really reflects the intention of the settlor. So lawyers, very important. Of course, if you need tax mitigation, you will need tax lawyers to come up with a plan to mitigate the incidents of tax. So lawyers are important. You need trustees, of course, corporate trustee, of course, because they are the ones that, you have a trust, right? So you need someone to administer the trust. I would say these are the professionals that you need at the minimum. Like I said, if you have got more other assets, then you may need to engage other professionals. But I hope people see that it is really a team-based approach. Now, Isaac, interestingly, after I wrote the article, someone texted me and asked me, say, Chris, wow, I need so many people. Is it going to be really, really expensive to hire so many people? The answer is yes and no, right? Yes, it cannot be cheap because you need a lawyer, you are paying corporate trustee, you are paying wealth advisors, investment manager. But relative to the amount of assets you are putting into the trust, whilst the cost is high on an absolute basis, relative to your asset is a small proportion. And I think it's important
to also highlight that if you are even considering engaging a corporate trustee, then the assets that you are intending to put in has to be quite substantial to begin with.
Yes. So, I've heard of people saying that, someone encouraged me to do a trust. I only got $3 million, $2 million. But they say, use a trust, right? And appoint a corporate trustee, right? I have my reservations. I think if the asset size is too small, the disadvantages of using a trust may outweigh the benefits of using one, right? So yes, at least at Provident, we try not to use expensive, complicated instruments, whether be it financial instruments or legal instruments, unless absolutely necessary. And I'm glad that our lawyers think the same. If there is no need to put in place complicated, expensive structure and you can still achieve your goal, then let's do that. The same goes with investment instrument, right? But yes, if your size of your asset is huge, in tens of millions, 50 million, then the cost of paying these professionals relative to your asset will be significantly small.
Have you been overwhelmed by market uncertainty in a landscape crowded with misinformation? Our new ebook, A More Reliable Way to Get Enough Investment Returns, is here to help. Each chapter is carefully curated to help you overcome confusion and empower you with knowledge that prioritizes reliable returns, guiding you towards a fulfilling investment experience. Check out the link in the show notes to download a complimentary copy of the full ebook today. Thank you, and let's get back to the episode. Right. So, of course, typically, if your assets are not huge, your needs are also not that complicated, and perhaps maybe having a human trustee is actually something that
absolutely
can fit your need. Of course, there's always advantages of having a corporate trustee that perhaps can last for, let's say, 100 years. But a human trustee, and mitigating in terms of having a human trustee pass on before the purpose of the trust, right? That can be mitigated with a few arrangements that you make on your end. So it's not always so drastic that you have to always fall back upon, or rather always go to a corporate trustee instead.
Yeah, and in our previous episodes on estate planning, we also talk about lifetime gift. Why wait until you die, then you give, right? So if you can avoid all these complicated structures, and if, in your lifetime you can start to give, then actually things can be really simple. So in legacy planning specifically, estate planning is really just about distributing your assets upon your demise. But in legacy planning, people always think that legacy only happens when you passed on. But no, you start your legacy when you're very much alive. Right? So our approach in legacy planning is we want to make sure that you are already building your legacy when you're alive. And therefore, sometimes some of these complicated structures may not really be needed. And you can save a lot of money as well.
Right. Earlier you mentioned a point about lawyers tailoring, helping you to tailor your trust deeds, right? And really it's not simply accepting the standard versions that the corporate trustee provide you, right? So what are some potential pitfalls of simply accepting the standard version?
Well, I can't really think of the specific, but like I said, I mean, if you are going to, I mean, these are the trustees, corporate trustees I'm talking about, right? And they have a standard template for their revocable, their irrevocable, their standby trust, and all that. And because they are trustees, these trusts are drafted internally by their own internal legal counsel, right? And in order to allow them to be able to function easily, they will want to give themselves a lot of powers, right? So they are not restricted. Now, I'm not saying that the trustees are going to lose your money, they are dishonest. No, I'm not talking about that. But naturally, right, if I'm going to manage your asset, I want to give myself as much flexibility as possible to manage it. I don't want to be constrained. But sometimes you really don't want them to have all the powers. You want to take away those things that are unnecessary. And in the standard template, they will put down a lot of all these clauses that are unnecessary. I've seen standard templates that talk about how to deal with companies' shares, but the client may not have company shares, right? That's unnecessary, but it's a standard, right? So the job of the lawyer is to go through that whole trust deed and strike off those things that are really not necessary, those things that are iffy. They clarify with the trustees. So nothing that I can remember on top of my head, but Isaac, we have done this so many times, right? We have never had an instance whereby the trust deed comes and then the client just sign and it's done. It's never done like that. And in fact, the part that takes a very long time is a ding-donging between the lawyers and the corporate trustee, right? My client says, don't have this, and all that. And the trustee say, no, but we cannot. If we cannot manage the trust if we don't have this, and then you go back to the client. So these things takes time, but ultimately, that's what you pay the lawyers for. They act in your interest. They want to make sure that the trust deed ultimately that you sign protects your interests, protects your beneficiaries' interests, and I think it's worthwhile. How much does it cost? 10, 12,000 for the lawyers to look at the trust deed, protecting tens of millions of assets. I think it's money well spent.
Yeah. Off the top of my head, I can think of another thing that was challenging is really about how certain clauses, perhaps maybe it's fine today, but when we're setting up a trust that's supposed to last for, let's say, 100 years, it could potentially pose a problem 50 years later.
Yeah.
Right? I think that's the part where sometimes as we're going through the trust deed, it's quite challenging, but of course it's important that we consider all these so that your future beneficiaries will not have to face these problems moving forward. I think that's one of the things that I feel is why it's important to tailor the trust deed specifically to your broader wealth plan.
And since you talk about wealth, something that is put in place today, 50 years later may not be relevant, is exactly the point why you need a team, right? You may put an investment mandate. I've seen it. You have seen it, right? An investment mandate that the trustee gives for the settlor to decide what kind of portfolio they want, conservative, balanced, portfolio. It's so vague. And you really want to be clear, but not too over specific. So that's the balance, right? Because if you are not clear, the investment manager can do anything.
Yeah, what's conservative to you is not conservative to him.
I may think that private credit is very conservative, but actually it's not, right? Yeah, so you want to be a bit more specific, but you also don't want to be overly specific because the instruments that is available, the philosophy that we are thinking right now may not apply to the new world 50 years time, right? But how would you expect the trustee to know that? They are not investment professionals again, right? So you really need to work with the investment professional to come out with an investment policy statement, an IPS, that is specific enough but still able to stand the test of time if the world change, if there are new instruments. So I'm belaboring the point. You really, really cannot just depend on the trustee to help you do that. That is not their job.
Let's talk about the role of wealth advisor. Of course, earlier you mentioned that the wealth advisor, in terms of technicalities, they are doing the cash flow management and all that. But beyond that, you wrote in your article that the trusted wealth advisor is often the only professional who journeys with the family over decades, understand their values, guide their life decisions, and ensure their plan remains relevant. So, so beyond the cash flow management and all the technical stuff that the wealth advisor do, could you expand on why the role of a trusted wealth advisor is so important in this process?
Well, in the team, the wealth advisor is the generalist. The lawyers, the trustees, they are specialists, right? And the job of the generalist is very important because the wealth advisor is probably the only professional in the team that has a complete picture of the financial situation of the client, right? And the wealth advisor is probably the only professional that understands the ikigai goals of the client. The wealth advisor is the only person probably that has spent enough time with the client and the children, and so he knows the intent. Right? And it's very important to have this person to be the centerpiece of the plan, right? Because one plan will affect the other. And because the wealth advisor has such an holistic view, he is able to coordinate the pieces, right? He's able to, and I've done that before, right? Look at a trust deed that is written and then be the spokesperson, be the voice for the client, right? In a meeting with the lawyer, the wealth advisor will be able to come up and say, for example, and tell the client, but Mr. Client, remember you told me about this? Do you really want the will or the trust to be written that way? Yeah, because it doesn't seem to reflect your purpose and intention that you shared with me. Is that the tone you want in your letter of wishes? Because that's not the tone you speak to your children. I'm not talking about their competence. They are very competent. But because they are not there in those family meetings which wealth advisors are, they may not understand these nuances, right? So we will be there to be the voice and say, do you really want to put down so many of these clauses? It seems like with these clauses, the message you send to your children is one of mistrust. Is that what you want? We would be able to do that, right? So that is why I say the role of the wealth advisor is so critical. We probably meet our clients more often than any of those professionals. We meet the clients a few times a year. There is a regular review. We are probably the first person to know certain things have changed, certain dynamics have changed in the family. We will be the person who will say, oh, remember that plan you put in place? Maybe we need to do some replanning. That's why it is so important. Otherwise, your plan that you put in place, your trust deed that you have written in that drawer, it could be dated after a few years, and nobody is going to review it. You think that everything is okay, but actually circumstances have changed.
Right. Lastly, it's really a question that I think you touched on for your last point, but it's really about how we have talked quite a bit about why it has to be a coordinated, multidisciplinary process throughout this podcast. But why is it so important that it is values driven as well? So you mentioned a few things about how the wealth advisor can step in to say that based on previous conversations, this, are you sure this is your intention and all that? But beyond that, why is it important that it's also values driven when it comes to setting up a corporate trust?
If I give you a knife today, you can use the knife and chop off meat and make food for your family.
Okay.
You can use the same knife and kill someone. The values that you communicate will be different. Through the knife, you communicate your love for the family, or you can use the same knife to communicate the hatred for a person. Money is that knife. On its own, it has no meaning. It can be used for different purpose. And that is why we need to understand what the deep-seated values of the settlor, of the clients are, so that in the plan that we create, we use money in the form of assets, properties, investments correctly. We don't use money to hurt. We use money to communicate that values that the settlor really want to communicate. And that's what legacy planning is about. Legacy planning is not the distribution of money. Legacy planning is the perpetuating of values. So that is why, we always talk about values, we always talk about ikigai, because ultimately that is purpose of the plan.
Right. Okay, with that, that's all the time we have. Thank you once again, Chris, for your time today. And to all our listeners, I hope you enjoyed today's episode. If you like this episode, please don't forget to like and subscribe if you haven't done so already, so that you don't miss out on future episodes. As always, thank you all for listening and watching, and I see you in the next episode. All analysis, views or opinions from interviews, recommendations and other information broadcasted, podcasted or published herein are provided for general information purposes only. Information expressed does not take into account any specific situation, particular needs or objectives, and should not be construed as specific advice or a recommendation. Information has been obtained from sources that are deemed to be reliable, but their accuracy and completeness cannot be guaranteed. Always consult with a qualified investment, legal or tax professional before taking any action. Provident Limited does not accept any liability for any loss whatsoever arising from any use of the information broadcasted or published herein. All contents and information contained herein may not be copied or reproduced in whole or in part by any means without prior written consent of Provident Limited.